Mr. Jeremy.
References are in the transcripts to the concessions made about the emails. I won't go through them in detail right now. I'll identify them, and if Mr. Jeremy wants to speak to them, I'm sure he will, and then if I need to return to them at the end. But they are page 499 at line 23. It goes over the page to 500, line 1, where the answer is. And page 513, line 17. Oh, sorry, yes. That's okay. I'll do it like this. It's okay. Yeah. Page. Thank you. Thank you. Yes, it's page 513, line 17 to 21, and then the question's answered again at line 26. And then it's page, so this is page 513. The questions are at line 17 and line 26.
Thank you.
And then at page 514, the question is line 11. And line 20. Those are the questions. And then at page 515, it's line 18. That's it. Thank you for your time. I don't have an answer on pages 105 to 111 of the trial bundle yet, so I only have a provisional answer. I'll see if we get an email through during the course of the afternoon.
Thank you. Mr. Jeremy.
Lord, thank you. When we broke, I had looked at the pleadings, and I had looked at those pleadings in respect of the point that the entire case proceeded on the basis of business loans, campaign donations.
Yes, I don't think that is disputed. I think that's an established fact.
Yes. So, my Lord, it's unsurprising that the cross-examination and the evidence followed that pattern. So I'd like to carry you to the evidence quickly, because if I could just say that we've had a caucus, and my learned friend is going to attempt to do what he can with respect to the bias point.
Yes, but before we go into the evidence in any detail, what is your submission going to be when we've seen the evidence? What's the legal submission that will result from our examination of the transcript?
My Lord, my point is this, that the finding of the judge was not tethered to the pleadings and the evidence in the case. That, if that is correct, that constitutes, of course, something that the Court of Appeal must look at, and if it is material enough,
is that something different from, is this submission something different from the 4 errors, or perhaps potentially 6 errors that the Court of Appeal identified?
Well, our approach in the written submissions is to treat the errors, as my learned friend has illustrated them to be part and parcel, really. They bleed into each other.
Yes, your written case, you say you can't look at them individually, you have to look at them holistically.
And the cases say that this is not legislative drafting, it is not contract interpretation.
No.
You look at the matter in the round. And that's what I'm attempting to do.
Yes. But are you seeking to advance an argument that it wasn't open to the judge to treat each witness's position as a curate's egg, i.e. that he would accept some of it, some of what a witness said, and not other bits?
That the judge could have a sort of an a la carte approach to the evidence.
Yes. Well,
Take bits and pieces. No, my lord,
is this submission, taking us to the transcript, going to lead to your analysis ultimately of the 4 alleged errors?
well, it feeds into the emails. It does touch on them because it's in the evidence before the court.
Well,
But
I'm not quite sure where you're taking us at the moment, but I will let you proceed in the meantime. But I don't think it is open to advance an argument which wasn't put before the Court of Appeal, if that's what you're seeking to do.
okay, my lord, perhaps if you give me a certain degree of leeway, there are certain things which are stark on the evidence, and I will not be long.
Well,
So,
proceed then.
so we say that the dispute is business loan, campaign contributions. Now, there's a curious thing that jumps out at you in the evidence, and it is this. I'm not going to take you in any detail to it, my lords, but if you look at the way the appellant's counsel treated with the evidence of the respondent's evidence was provided by Mr. Warner himself. It was provided by
Philip and Hussein.
Hussein and Philip. So if I could just quickly carry the board to this. The cross-examination of Warner, for example, that takes place on the 7th of May 2018. And it begins at EB 438. 438.
38. Okay.
The cross-examination follows the formalities of having the witness sworn, his evidence tendered. Now, I've checked it in the transcript. The formalities of having Mr. Warner authenticate his signature, identify the witness statement as his own, confirm that he provided a witness statement. Well, those formalities on the transcript took something like 27 lines. He's cross-examined by counsel simply asking him if he would, essentially, if he was speaking the truth. Now, so 27 lines to authenticate his witness statement, 16 lines in cross-examination. At least that's how I count it. I might be wrong. So to use a baseball analogy, he's walked. There are no questions of Mr. Warner apart from the fact, are you speaking the truth? And that is a pattern that follows. In the case of there are only 3 witnesses.
Mr. Warner, that it was a loan rather than campaign financing, specifically.
I'm afraid I didn't hear the question, my lord.
Sorry? It was put to him, wasn't it, that they were loans? Age 439 at the bottom.
And then then counsel sits.
Right?
Then counsel sits.
Yes. But There was no challenge made to Warner's evidence that the money was connected with a political purpose or political funding.
Absolutely.
What was put to him by the claimant's counsel was that these payments were loans.
Yes.
So what do you take from that?
Well, Mr. Warner did not only say that the funds were for political purposes. His evidence was, and it's there, he was asked about repaying the loans, and he said that was never a part of it. These were donations.
Yes.
So that's I think 2 lines.
But what are we to deduce from the brevity of the cross-examination?
Well, that in the main, his evidence, which is set out by the judge, is unchallenged. And I'll come to summarize that evidence in a minute. It's the same with Mr. Hussain. He's called formalities. I counted again, 37 lines. His cross-examination is 6 lines. He's asked only, in his case, if the account you give in the witness statement is untrue, to which, of course, he predictably answers that it is true.
Which page can we find that on?
That is
4.2.
EB 441 to 442.
Thank you.
And the other and last witness for the respondent, that's Mr. Phillip. Well, his stint in the witness box is about 3 minutes, I calculate. 27 lines to swear him in, 13 lines of cross. Essentially, again, are you speaking the truth? My Lord, this is where I come to summarize what...
He's put to both those witnesses that their statements are untrue.
Yes.
And the judge does, in relation to each witness, make the point they weren't cross-examined extensively, and he does identify the one point that was put to each of them.
Yes, yes, my Lord. And he also says that there is no evidence, he has no reason to believe that the evidence is contrived. So it's unsealed. Now, in that evidence is evidence about a meeting at which Mr. Lala agreed to fund the UNC through companies including the Center of Excellence, campaign contributions, millions of dollars lying about, and in the case of Mr. Warner, about the fact that there is no need for repayment of that money, not surprisingly. Now, in the cross of Mr. So that's it for the case of the respondents.
Yes, the respondents were not cross-examined in any detail. It was merely put to them that they were lying. Where does that take your case?
My Lord, I would suggest it takes, if there is no cross-examination, there's no attack to the evidence of there's no sustained attack, there's nothing that checks the evidence of the witnesses for the respondent, then the judge, as he says, he can't say that the evidence is contrived.
Sorry, I didn't hear that.
The judge can't
say that the evidence is contrived. He says so. It's a fact that is mentioned by the Court of Appeal. And without any sort of direct challenge to it, it stands. Well, my little friend is prompting me to say that in those circumstances, it's not possible for someone to pick and choose.
If you could keep your voice up, please. I think we're not hearing you clearly, so could you project your voice a little? Thank you.
In those circumstances, it's not possible for someone to pick and choose bits and pieces that they see are useful to them.
You say the judge cannot adopt?
Yes, my lord.
Yes. Did you argue this in the court below?
No, I did not. But I'm here justifying the decision of the Court of Appeal to intervene holistically as opposed to.
But if the judge were to think, there's been no cross-examination here, but I have the evidence of Ms. Maharaj that she was told by Mr. Lala that this was a loan, and he also has documentary evidence suggesting a course of conduct of the advancing of money from Mr. Lala and his commercial interests to Mr. Warner and his commercial interests. Is he not entitled to weigh up the probabilities having regard to those two things, the oral evidence of Ms. Maharaj and the document?
Well, fortunately, Ms. Maharaj was cross-examined, and she said that she could not say for sure whether this had anything to do with campaign finance or a loan.
Yes. All her evidence is a contemporary statement by Mr. Lala that the money was a loan. She can't gainsay that. She can't say if it's true or not true, but she is speaking and was held to be credible that that was what she was told. And knowing that, the company thereafter didn't keep very good records by the sound of it. But it is still a factor that the judge is entitled to put into the balance, is he not?
He's entitled to do so fairly with all of the other evidence, my lord.
But she wasn't challenged. The proposition that she was told contemporaneously by Mr. Lala was not challenged and wasn't rejected. What she accepted was that subsequently looking back at it, she couldn't say one way or the other.
Yes.
But the conversation that took place did take place. It wasn't put to her that conversation never took place.
No, that was not put to her. Well, might I press on? So,
Please.
Now, in terms of the witnesses of the appellant, it's fair to say that Mr. Lala struggled. He confirmed that he had arranged a loan for business purposes for the center. But then, strangely, he exhibited a promissory note, which he said had been sent to him by Mr. Warner. Now, he admitted that it was not his intention when he annexed that note to suggest anything much from it other than it was a sample of how the transaction might in fact be done. But he admitted that there were a number of problems with the sample. His name and Mr. Warner's name were on it. this was a transaction that was to take place between corporate entities. Importantly, the repayment details were wrong. The instructions that he'd given to his lawyer said that this was a business loan to be repaid on a date certain. The promissory note had something about terms to the effect that it would be satisfied over a period of time. And when the various discrepancies were put to him, he said that he'd made a mistake. Now, that, my lords, and I'm not taking you to the page numbers, well, all of the page numbers and the references now, but if you look at EB 485, EB 486, EB 491, EB 499. I think you get a sense of his evidence and the difficulties that he had. He did have a considerable difficulty with respect to one email that was headed UNC payments, because remember, these are his emails. He's tendering them. And with respect to that, he says, yes, I agree that's written there, but I'm not financing any UNC campaign. That's EB 504. Now, my lords, we see in respect of
what is this document that he was, it's the penultimate email, is it? What is the document he's commenting on at 504?
It is an email, my lord.
Yes. Can we see the document? He said his position was he wasn't funding a campaign. Now, he clearly wasn't believed in that.
Yes.
But what can we look again at the document? It will be at about in the range of about 290 or 289, somewhere around there.
I think it's 287, yes, UNC payments.
So
The email entitled UNC payments is at 287.
287. Oh, I see, yes, forward UNC payments. Yes. And that is an email by Mr. Warner writing to Mr. Lala.
Exhibited by Mr. Lala.
Yes, I can't, that's December the 7th, 2007. Thank you.
Well, there are other difficulties with the emails. Many of them were written after checks had been disbursed, and Mr. Lala admitted that. EB 491, I'm not carrying you to it. So payments had already been made. And
So what difference does it make if a payment's been made?
well, if the email says something like, wire funds to me, and the subject of this matter is 5 checks, which have already been paid, then this might relate to other things, but not to the subject of our dispute. So, if you wish, my lord, I can take you to so it's on 491 and going into 492. I'm just taking you to the transcript.
Yes.
Sorry,
The cross-examination, 491,
line 1. Thank you.
bottom of 491 to 492.
Thank you.
The attorneys in the court below maintain that the emails were not valid. They were fake emails. We don't agree to the authenticity, he says, but these are wire instructions, like to wire money. And then he says so just above that, the emails come after the checks that form the subject matter of this claim were disbursed. And Mr. Lala says yes. So, I mean, that is a problem with that particular email.
Which particular email?
The email that we refer to at 491, my lord.
Yes. Okay.
So the instructions, the emails that have been talked about here, and I don't know if you can take us to them. You say they didn't mention that these checks that were paid were to be loans.
Yes.
But I don't think the appellant disputes that. The appellant's case, as I understand it, is that the judge was entitled to look at the emails as a whole and establish from that Mr. Lala had been advancing considerable sums to Mr. Warner and his corporate entities, including the one in question in this case, and that these wired instructions were part of that overall program of lending money. That I think is the point that's been made against you.
Well, if that alone were the case, then we would have no difficulty. The difficulty comes in if one maintains that there is evidence that in the emails that these checks were somehow acknowledged to be loans for campaign purposes or otherwise by Mr. Warner. And Mr. Lala says no. And if we can agree on that, then I can just see that Mr. Lala had significant difficulties with respect to his evidence.
How are these emails consistent with Mr. Warner's evidence that all the transactions were donations, not loans?
They are, because Mr. Warner's case was that he was receiving funds.
Yes.
His witness statement. He was receiving funds by way of donation from Mr. Lala and his associated companies.
Donations, not loans.
Donations, not loans.
Yeah, so what I'm putting to you is that the emails seem to be referring to loans, but that's not consistent with Mr. Warner's evidence.
The UNC email obviously does not. Lord, so it comes back to the core finding, so I've spoken about the emails, it comes back to the core finding of the judge, with which the Court of Appeal had a difficulty with, and we say rightly so. And that is the finding that Mr. Warner may have wanted to portray an image to the UNC that he was its main financier, and of course had sourced finance from Mr. Lala on the basis and expectation that sums advanced would have been repaid out of an anticipated payment, well, a business loan.
It's suggested on behalf of the appellant that that wasn't a central finding, that the central finding was, in fact, the emails and also the evidence of the general manager of the appellant, that there was a contemporaneous statement that it was a loan, that those were the central findings, rather than that this particular comment was a central finding.
Well,
what do you say about that?
My Lord, it was that finding that allowed the court to allow the judge in the court below, the High Court, to find that these were campaign contributions which were repayable.
No, I mean, it was Mr. Warner's case that these were campaign contributions, and that was accepted by the judge. This finding, which is on paragraph 4 onwards of your written case, is an explanation as to why campaign funding from Mr. Lala was being given to Warner's companies. Now, why do you say, what inference can you take from the fact that Mr. Lala was giving the funding to the companies of Mr. Warner, other than that Mr. Warner would be the person who would be dispersing those funds on the campaign?
Well, my Lord, I hate to speculate, I mean, but it's not evidence, but the fact is that in a small country, there are a number of reasons, some given on the evidence before us, by witnesses of Mr. Warner. That is to say, that the UNC, which was the party in power, did not wish to have funds coming to it in large amounts from ordinary people. There are other explanations. In the evidence of one of Mr. Warner's witnesses, which the judge said was not contrived, there is an account which says, well, funds might be given for purposes which are necessary on a day-to-day business. It's in the heat of an election campaign, funds are necessary on a day-to-day business, and I mean, I hate to call, but that the same donor might be given funds to other named persons, and those persons are named in the papers from other opposition, from other parties.
But why would Mr. Lala be giving Mr. Warner funds rather than using his various companies in his business empire to provide the funds directly to the UNC?
Well, it's actually on the evidence, my Lord. Did
Mr. Warner explain in the evidence why it was that he was receiving these donations rather than the UNC directly?
One of his witnesses did. This is either
my
Hussein or Philip.
my recollection, I could be entirely wrong, was the explanation you first gave that funds, the UNC didn't wish to have funds coming to it in large amounts by ordinary people. That explanation was given in discussion with the judge, submissions to the judge, and I couldn't find any evidence of it at all. So if there's evidence of it, where do I turn to?
Okay, so I am pretty certain that it is contained in either the evidence in chief of Mr. Sharma, who was then the treasurer of the UNC.
Right.
It may have been in the cross-examination of Mr. Sharma.
But tell me,
But it would have been at least,
sorry,
it would have been at least, my lord, given one of Mr. Warner's witnesses evidence in which he gave a reason connected to party donations in general. He said, this is Mr. Hussein and Mr. Philip, he said, listen, political parties receive funds from other political parties, and we do not wish, Mr. Lala did not wish it to be known that he received funds from Mr. X of the other political party. That is in evidence before you, from one of Mr. Warner's witnesses.
But the question ultimately isn't what was there. Were there various explanations given for this money going to Mr. Warner? The question must ultimately be, was the judge entitled to draw the inference from the payment of monies to Mr. Warner's entity that Mr. Warner was to disperse those funds and get the credit for it? I mean, why can't the judge make that inference from the fact that Mr. Warner was using the donations as he would have it?
Well, you know, it may be one of a host of reasons why money was sent to Mr. Warner. But it certainly would not be the only one, and I would hate to speculate on what the others would be. There's evidence to support at least two other versions.
Thank you.
Well, so we see that if you look at the evidence on a whole, including the email evidence, if you look at the evidence on the whole, we see that the Court of Appeal, that is to say, the fact that if that finding was not tethered to a fact, it was not tethered to the pleadings in the case, and for that reason, it was not open to the judge to make. We see that it was an identifiable error.
Just pick you up on one point. I mean, if evidence is led without objection of certain facts, are the pleadings then relevant, or is that evidence simply before the judge to make of it what he will?
Well, the pleadings define what the case is about. You could have pleadings which cases which develop as they go along. But the reason that I took you to the pleadings to start off, and then I took you to the transcript with the evidence, is to show that these parties maintained throughout that this was either a business loan or a campaign contribution. So this is not a case where you have pleadings at the outset which demarcate the dispute between the parties and matters developed during the trial. The evidence was consistent with pleadings, and the judge had no warrant to make a finding which was not tethered to the pleadings or the facts. So, my Lord, we say that the Court of Appeal was correct to find, as they did, that there were identifiable errors, that this was a finding for which there was no evidence. You may have had speculation as to why this might have been done one way or the other, but there was no evidence. They were correct on that, and we submit, our submissions are that the appeal should be dismissed and the decision of the court should be affirmed. Lord, my friend has, my learned friend would like some minutes to convince you on the bias point.
You've addressed us on the first criticism. Are you wanting to address us on the other criticisms as well?
My Lord, that is the main one. And
it's the main one.
For us, we've left the others to our written submissions, as well as to our comments on...
You're fully entitled to do that, yes.
Our comments on the additional reasons given by Jones J.E.
Thank you very much indeed, Mr. Jones.
Thank you.
I wonder if you could switch so that you can...
Yes, so I can go in the middle.
So you can be before the microphones. Thank you.
My Lord, the board has a written case on the bias point at 669 to 670. I'm not proposing to take any different course than that, but what I will do with the time I've got is just emphasise some aspects of that. I've been made aware by your lordship, I face something of an uphill struggle. I have to say it's usually that respondents were not called upon to respond to my appellant submissions. No. But I find myself on the opposite side of the court.
Sometimes, Mr. Thomas, it is a better use of time to require a respondent to justify a case made by a lower court or a judgment of a lower court where the board is concerned that it has gone wrong.
Yes.
Yes, you're perfectly free to, and I welcome your submissions.
I'm going to begin my submissions a bit like my learned friend Mr. Strang did, which is to say the court applied the correct test. They approached the evidence in the right way. They reached a conclusion on that evidence, and we say that in those circumstances, the outset, this court should be very slow to interfere. So that's our headline submission.
But it was a majority decision.
It was a majority decision.
Yes, and you'll have to address the dissenting judge.
Yes. Well, perhaps. Yes, if my lord doesn't mind, if I can address that as I go through it. Take
it as you please.
Yeah.
Thank you.
And what we do say, as the court's aware, is that in addition to the same judicial restraint that Mr. Strang urged upon the this board. We say the same, and of course we say, and it's in our the final paragraph of our submissions, that that's particularly the case when the notional fair-minded observer is a member of the community in which the case arose and will have possessed an awareness of local issues and social and political reality that forms the backdrop to the case gained from the experience of having lived in that society. And whilst we acknowledge it was a majority decision, we say that that doesn't weaken that submission. So that's our headline. I'm going to adopt the same structure. So I'm responding to the written case of the appellant. And what we say is that in that case, the appellant has relied upon a number of individual authorities that deal with particular factual scenarios. What we've said is that we would urge some caution as any attempt to compare one particular facts to another. It may be that going beyond Porter and McGill and the Attorney General and Kubla Singh, to the extent that obviously is a local case from Trinidad, is not necessary. I'm just going to give the two references as to why we emphasise that point. In EB 783, paragraph 25, that's Lord Bingham in Lochaber saying it would be a dangerous and futile attempt to define a list of factors which may or may not fall one side of the factors either way. And again, Davidson, same judge, EB 694, paragraph 17, again, impossible to lay down hard and fast-edged rules. Now, the appellant, in its written case, focuses, we would say, and it may be the board reaches a different view of this, but we would say it emphasises and focuses its analysis on what was said during the proceedings. We, of course, don't seek to emphasise that. Our emphasis is on what the judge said in his reserved judgment, and then what was re-emphasised, that's an unattractive use of language, again in his speech, what is about 9 months later. And to the extent, that the appellants embark upon a careful analysis of the various interchanges between the judge and counsel, we rely, as we have done at paragraph 28, on Lord Bingham's approach in Davidson and the Scottish ministers. The court will recall that related to some comments Lord Hardy had made during his time as Lord Advocate. And in the context of that, a careful analysis of the very particular provisions and what was relevant and what wasn't was embarked upon. The reference is at EB 689.
I don't know about my colleagues, but coming as I do from that jurisdiction, I remember the case vividly.
I'm taking this at a lightning pace, partly because of the timing and partly because I'm aware these are very familiar provisions. It perhaps
You're right, it's a broad assessment.
Precisely, and it's the wood and the trees, I think, is what Lord Bingham said.
That puts it very nicely.
So you have the reference. Now, if that is where the test is at, and it's I think my Lord commented on this at the beginning of my Learned Friends submissions. I don't think this is a case where the test is in fact in dispute. It's the way in which it's been applied. The question, therefore, is, and can I just, I think, can I take the court then simply, having established in my main submission that perhaps we don't need to go beyond Porter and McGill and Attorney General and Kubler Singh, I am going to just take the court to Kubler Singh, which is at EB 673. The the appellant in its written case, I think concurs that this summary at the beginning is an accurate and proper one, which goes from the beginning, and perhaps is particularly found at paragraph 8. And I've already dealt, I think, with submission A about reserving judgment until understanding everything. That isn't to be read as a sort of a very close textual analysis. It has to be read in the context of the wood and the trees. And we say that the headline here is the language that is used, which I will come to. Now, we also emphasise, I think as the board knows, D, which is he is a member of the community in which the case arose, so this is at 675, and will possess an awareness of local issues and the social and political reality that forms the backdrop to the case.
The board is very aware of the restraint that is upon it for that reason.
Yes, and I hope the board will forgive me for emphasising it in the context of this case.
Fully entitled.
In fact, I'm going to what I think is called double down now, just by taking the board to the Canadian case on which the appellants rely at EB 1108. The board will find it at the bottom of 1108 in the left-hand column, unless one wants to read it in French. And it's the nature of the community, and that who is the reasonable person. If one goes over the page halfway down, 109, the reasonable person is not only a member of the Canadian community, but also more specifically is a member of the local communities in which the case at issue arose, in this case the Nova Scotian and Halifax communities. Such a person may be taken to possess knowledge of the local population and racial dynamics, so on.
Yes. Sometimes I wonder if, in assessing this construct, the informed, reasonable person, judges may be guilty of over-analysing. But
I'm not going to be tempted into a response.
But you're certainly right that one of the factors is the local knowledge.
And as my lord's aware from just the factual background of this case, is dealing with political issues, with well-known personalities, with a sense of the impact on the community. And I hope the board don't think it's discourteous if I do just emphasise that in those particular circumstances, we do submit there should be particular restraint. I'm not going to take it further than that.
I think that point is one of which the board is aware.
It's also the way I put it, though, really is to build it into the same way Mr. Strang started his submissions, to say one has to weave that into the fact that there is no criticism. If one goes at perhaps at EB 208,
Before leaving local knowledge, of course, it's a split decision, isn't it? So a judge with a lot of experience in the community came to a contrary view.
Yes, and the majority, I don't think I could take it further, my lord, than to say the majority, which must reflect the majority, came to the view they did. At EB 208, I go there only for this purpose. That is the approach that the court takes. In the Court of Appeal has taken, it has set out at paragraph 42 the correct test. It's also set out the correct two-step approach. It has over the page at 43 then looked at what the relevant circumstances are, analysed those, and then reached its conclusion, which is at the top of 213. These statements in their entirety would lead to a real possibility in the mind of a fair-minded observer that the trial judge's personal views on the morality or ethics behind unregulated campaign financing coloured his views against a public official like Mr. Warner, who accepted unregulated campaign funding. And so, as I understand it, there is no criticism from the appellant of the approach that is taken. The criticism from the appellant is of the conclusion that was reached. I was, I think, in Davidson, and I'm just searching for the reference.
They criticise the circumstances identified, don't they? They say there were other relevant circumstances. These weren't all relevant circumstances.
Yes, having not heard the argument developed in... Yes, I was just trying to... but perhaps if I am going to answer that question properly, I am conscious of the time. I do need to go then to their case on that. And if my lord would be kind enough, if there was any particular aspect...
Well, paragraph 84, they did not consider all the relevant circumstances, and then they set out various circumstances.
Well, yes, I think what the way I dealt with that was perhaps far too broad brush, was to say what they then go on to do is a close analysis of the exchanges at trial. And we say that's just to miss the point. That's not where we're targeting our focus.
No, but if you stand back from the detail, they're recorded in 84 onwards. The point being made is a very simple one. Mr. Warner's case was this wasn't a loan because Mr. Lala had said, what's in it for me? And he knew very well what was in it for him. What was in it for him is that the government would award him contracts. And this reflects badly on Mr. Warner, and it also reflects badly on Mr. Lala, if it's true. Because in bribery, there's the bribe taker, but there's also the bribe giver, and neither come out of it with credit.
I hope my lord doesn't think this is avoiding answering the question. What I am going to do first is just answer that by reference to Davidson. I don't know. I don't think I need to take the board to it. It's at EB 690, where at paragraph 9, where what was said by Lord Bingham was what Lord Hardy said might readily be accepted to be a bona fide expression of personal opinion, might be orthodox and might be held to be correct. That same might be said of views expressed by the trial judge in this case, is what we submit. It's not a...
How could you have a contrary view to that? In essence, the case that was being run was there were going to be kickbacks for campaign donations in the event that the UNC were elected. And how can there be a contrary view that that was highly improper?
I'm not going to suggest that in the expression of opinion on campaign financing, that is not, as I've said, and the reason perhaps I was slightly evading it, was an entirely orthodox opinion. The way we approach this, though, is to take the second part of my Lord Hodges' question, which is, well, this was aimed at both of them, wasn't it? Which is the point taken by the appellants. The way we deal with this is if one goes to the language, it is very much focused on, and it's at, well, I should say here, if one goes to 159, what we have here, I'm afraid the appellants very helpfully appended to their written case what might be called a clean copy of the, but it hasn't made its way, I'm afraid, into the electronic bundle. I know that they've made some attempts to provide it.
I can say it's been re-emailed to the court. It was re-emailed to the court at lunchtime, so if it's helpful to look at a clean copy of the speech, we may be able to, your lordships may be able to get hold of it.
For my part, I was going to confine myself that the emphasis, we say, which is in both the judgment and then repeated in the speech, is there is an entrenched public perception that elected officers can be sold to the highest bidder. We say the emphasis is on the role of elected officials, and that if then one is applying the test as to what is bias, I think I'm returning to, I don't think there's any controversy in this, the very first page at 673 of Kubel Singh. The test is an objective one. In essence, it requires the court to ascertain the view of the public through the eyes of a fair-minded observer, whether the judge or would not be biased. And then the next bit, bias is an attribute of the mind which prevents the judge from making an objective and impartial determination of the issues he has to resolve. Now, the emphasis, as it was submitted in the court below, and the way that the Court of Appeal were considering it, was that in circumstances where, and I'm dealing with the Court of Appeal's treatment of it, campaign funding is not illegal, and in circumstances where the emphasis was on the role of public officials, that the language used by the judge and repeated.
Campaign funding wouldn't be illegal, but getting kickbacks would be unlawful for both of the parties.
Absolutely. If there was a clear arrangement where you pay X money and you get X contracts, then of course, yes.
And Mr. Hussein's evidence was quite florid about it all, that Mr. Lala literally laughed. I'll give you as much money as you want. I'm going to be repaid tenfold. I mean, that's...
Well, I think, and what I hope I'm not seeking to avoid it. Well, I'm trying to sort of plough a furrow of looking not at the rights or the wrongs of this, but the circumstances in which a judge in those circumstances is entitled or it's appropriate to make the sort of comments he was, and then to repeat them in circumstances where the case on which he'd given judgment was under appeal, and to put them in the terms of, I think the words were, cancerous impact on the Republic.
Is there anything here, Mr. Thomas, which reveals a predisposition on the part of the judge to decide the case by taking account of considerations he should not take account of?
If in terms of predisposition in the sense of before the hearing itself, and I'm just being careful about my use of language, No, in the sense that I'm restricting my submissions to what he said in his judgment and what he then said in his subsequent speech.
And neither before nor during the hearing.
So, yes. Yeah. That plainly has to be the case.
So the judge is simply commenting on matters arising out of the hearing and the evidence that he's heard?
Yes, it's in the reserve judgment, has gone away and has reflected upon matters. And then these are obviously opinions that he's formed during, at some stage, either through in the hearing or during the time for reflection. And they come at the same time he's delivering judgment. So yes.
In those circumstances, what is there which founds a reasonable apprehension of bias?
Well, I think what the authorities establish is that, and I know that, if my Lord could just give me a moment, the appellants have looked to the authorities, Lochabail, Vakauta and Hoekstra, in terms of what judges can say.
Yes, well, in Lochabail, one of the 4 cases in Lochabail did concern the previously published statements by the judge. They'd been published before the
and in that case, there was
they were tendentious. They were expressing a view on behalf of one side.
Yes.
We claimants.
I think it has to be noted that in all of those cases, in fact, there were findings that unconscious bias did exist. So to the extent the appellants seek to rely on them for the principles they do, and perhaps one of the examples was Hoekstra, in which the judge wrote an article about the ECHR. Perhaps the best I can say is that when one looks at that authority, what the court says is, well, if it had been expressed in a different way, and if it had been expressed in a legal article about some of the challenges that might be faced by the ECHR, things might have been different. But on the way this was expressed, it was unconscious bias. And I think I have to adopt the same line, which is, it may well be there were circumstances in which the judge could have made his disquiet clear, but doing it in these emphatic terms and in a judgment and then in a public speech crossed the line.
But in Hoekstra, the views expressed would have revealed a predisposition to favour one side rather than the other.
Well, I think and it's probably pedantry, the problem I'm having with the word disposition is that I don't suggest this is there is any evidence of this judge coming to these hearings with a predisposed view about campaign finance. I don't say it, so it is different than Hoekstra to that extent. But what I am saying is that having heard and having started to reflect and think about it, instead of focusing his judgment and then on what might be the issues that were in dispute, he then went further to make comments which even even the judge in minority accepted he shouldn't have said.
Oh yes, the respondent, what was then the respondent's argument that the judge was entitled to set out his views in this way is not something that's being argued before us.
Well, I think I was just going to gently touch on that. I wasn't quite sure when in the appellant's case it said these comments were understandable, whether that was in fact being argued, but I don't think it is.
No, but it was a response to a defence put forward on behalf of Mr. Warner, which was rather egregious, which was that this was a corrupt deal and that Mr. Lala was involved in it as well as Mr. Warner.
And I don't think I can take the answer further than the way in which I'd done it on Hoekstra, which is that there is an opportunity for a judge to comment, whether in a judgment or outside, on that. But this has gone the wrong side of the line. And then I hope I can return to the point I've made, that it is quite difficult to draw where that line is. I've already made reference to those authorities. the Court of Appeal, the local court, obviously decided it went the wrong side of the line, and therefore we say that should be upheld. And I haven't specifically gone to the minority judgment, but what I do say is even at the end, the judge says that this shouldn't have been said. It's judicial activism, and the way the minority judgment ends doesn't. It can't be said to be emphatic support from that member of the local community for this being said, to that extent that...
Paragraph 89 is absolutely clear as to the minority judge's judgment.
If you could give me a moment.
On page 226 of the bundle. And paragraph 90 is the consequence.
Yes. Well, I was referring to 91.
Of course.
Yes. Well, I don't think there's any pushback from the board in relation to 91.
All right. Well,
in relation, I think you're accepting that at an earlier stage, the judge could have, but didn't take into account the outrageous proposition that was being put forward.
Well,
what was essentially being alleged was a corrupt deal by Mr. Warner. And so the judge, in analysing all that, if he'd gone into it in huge detail, could have said, well, one of the factors I'm looking at is whether or not there was this an allegation of corruption.
Yes, I'm trying not to overlap the 2 points, because we're very careful to say, and it was put below, only ever argued as unconscious bias. I'm seeking to avoid saying that, well, this is what the judge in fact said.
But I don't think you're joining issue with the proposition that the exact nature of the relationship or the exact nature of the arrangement could have been analysed at an earlier stage in the judge's judgment, if he wanted to.
Yes.
Yeah.
He could have explored the evidence on that issue.
And he could have said that it was, what was being suggested was corruption.
All I would say is when the line in the, I will speak to my learned friend in a moment, the line in, there is one line in Mr. Warner's witness statement about this, and then there is, I think, 1 page of cross-examination about it. So to the extent that that was raised, then of course, yes, he can comment on it.
Well, Mr. Hussain goes into it in some detail.
Yes, he goes into more detail.
So it's a joke between the 2 parties.
Yep.
And,
again, I'm just going to, one second. Yes, the question was whether he could have dealt with it in his judgment. I think the answer, of course, has to be yes. I think the way I was fearful it does overlap is I think what my learned friend's submissions have been is when one looks at what the issues were in the pleadings as to whether it was a business loan or whether this related to electoral funding, it was perhaps not entirely central to those 2 issues. I don't think it would be, I can press it any further than that. Can I just take 1 moment to make sure I've dealt with matters? No. Unless, do you have any questions?
No question.
No, thank you.
Yes, Mr. I should say you do not need to address us on bias.
Thank you, my lord. Might I just...
I'm sorry for your colleague who is missing out.
I'm sure he'll get another chance, my lord. There's just one point. When my Lord Hamblin asked about the appellant's point that the circumstances weren't taken into account, and my Lord Hodge put back to Mr. Thomas a slightly different proposition, because it is right that our case, part of our case is that the circumstances weren't taken into account by the Court of Appeal. And if you were to look at the transcript, you'll see that the judge is separating out the question of loan versus gift from his reaction to the morality of the proposition. He doesn't let his moral reaction to the proposition intrude upon his assessment of loan versus gift, if you look at the transcripts that we've set out in the case. So that was the point that my Lord Hamblin had identified, which is somewhat different from my Lord Hodges' point. Otherwise, responding on the question of fact, I really only have a couple of things I'd like to say, and it's in response to the point that the judge can't pick and choose given the paucity of the cross-examination. But there's two things I'd say about that. First, it's a new point, as my Lord Hodge identified. Second, it's a point that acts differently on Mr. Hussain and Mr. Phillip than on Mr. Warner. Because Mr. Hussain and Mr. Phillip were both asked only, your evidence is untrue, isn't it? That's all they were asked. But as for Mr. Warner, that wasn't what he was asked. He was asked, it wasn't put to him that his evidence was simply untrue. What was put to him was, this was a loan, wasn't it? And your lordships will recall that all that Mr. Warner had in fact said about that is at page 231, in the middle of paragraph. That's not. I've got the wrong reference. It's in Mr. Warner's evidence in chief witness statement. So it's probably oh, that's the old lettering. It's 316.
Starts at 314.
316. So all that Mr. Warner says about loan is in the middle of paragraph 11, and no time did I indicate or lead Mr. Lalla to believe that Mr. Lalla was giving me or any of my companies a loan. And what was put to him effectively was, yes, you did. Now, one might be asking, well, of course, the appellants could have put to Mr. Warner all those emails. They could have asked him for his case about the emails. But as you saw in cross-examination, the respondents didn't accept that the emails were authentic. Mr. Warner was not accepting they were authentic, but he wasn't advancing a positive case about them. So no case was put to the appellants or to Mr. Lalla, these emails, you forged these emails, you've made them up. All that Mr. Warner's case was that he was disavowing responsibility for sending these emails. If that was his case, then the appellants were entitled to say, well, if you're not taking ownership of these emails, we don't need to ask you to explain them. So,
and there was no explanation as to why, as far as I can see, why Mr. Warner was saying the emails were not authentic.
No explanation and no positive case advanced. So, while it is a narrow cross-examination of Mr. Warner, in the circumstances, it's far from fatal to the appellant's case or the judge's judgment. Those are my submissions.
Thank you very much. Well, the board is very grateful to counsel for their submissions, and also to those who have assisted counsel in enabling them to make their submissions and producing the documents which the board has to consider. The board will take time to consider their judgment.